it is my profound privilege and an honor today that we at Faculty of Law, University of Lucknow is organizing a webinar on intellectual property law and its interface with access to education and access to health. We have a very distinguished guest today with us, Sri G.R. Raghavendra ji. Though I don't need to introduce him, he do not require any introduction, but I will give that particular introduction because that is something which is an honor for us. But before starting that particular point of our discussion today, we are blessed today with us our Head and Dean, Professor C.P. Singh sir, who is a motivation behind this particular deliberation. And most importantly, our Honorable Vice Chancellor, Professor Alok Kumar Rai sir, who is an inspiration behind all these deliberations and all these academic endeavors. As every one of us knows that intellectual property law is a very, very important kind of a deliberation when it comes to access to education and when it comes to access to health, because everybody talks about medicine, everybody talks about cancer medicine, generic drugs, everybody talk about right to education. But the point of contention is, in a very competitive market and in a scenario where we'll have to provide 140 crore people access to education and access to health, the role of intellectual property law becomes more important and more imminent. And that is why today we have deliberated upon this important topic. To start with this deliberation, I would like our Head and Dean, Professor C.P. Singh sir, to please give an introductory remarks. Please, sir.
Thank you, Varun. Respected Sri G.R. Raghavendra, Joint Secretary, Ministry of Law and Justice, Government of India, Chief Guest of this event, Dr. Varun Chachar, Program Director and Assistant Professor, Faculty of Law, Lucknow University. Sir, dear participants, sir, लखनऊ विश्वविद्यालय का वित्त संकाय आपको इस इवेंट में ऑनलाइन आने पर स्वागत करता है, वंदन करता है, अभिनंदन करता है। फैकल्टी आपकी सदैव इसके लिए आभारी रहेगी। वरुण चाचर ने जो टॉपिक चुना है वो बड़ा ही रिलेवेंट टॉपिक है, इंटेलेक्चुअल प्रॉपर्टी लॉ एंड इट्स इंटरफेस with access to education and access to health. Very burning issue, very burning topic. देश में बौद्धिक संपदा की, इंटेलेक्चुअल प्रॉपर्टी की कमी नहीं है। हम लोगों को अधिक जानकारी न होने के कारण फॉरेन के लोगों ने उसका फायदा उठाया। एक इलस्ट्रेशन दे रहे हैं कि विदेशी लोग यहां राजस्थान आते थे और वो देखते थे कि कुछ लोग ऐसे हैं जो एक पत्ती चबाते हैं, उनको भूख नहीं लगती है। उस पत्ती की उन्होंने मोटापे की दवा बनाई, वेट कम करने की, और उसका पेटेंट ले लिया। बाद में पता चला, हालांकि कुछ जो है पैकेज के थोड़ा बहुत प्रॉफिट लेबर्स को, वहां के लोगों को दिया गया। तो ये चाइना में इस तरीके के 5000 इंस्टीट्यूशन है जो इंटेलेक्चुअल प्रॉपर्टी से रिलेटेड है, जानकारी देते हैं। भारत में पहले तो थे भी नहीं और अभी भी बहुत कमी है, और बहुत कमी होने के कारण लीगल अवेयरनेस, इंटेलेक्चुअल प्रॉपर्टी के प्रति अवेयरनेस न होने के कारण इसका फायदा फॉरेनर्स उठा रहे हैं। चाहे मेडिकल के उद्योग में हो, आयुर्वेद के मामले में हो, या हमारी क्राफ्ट के बारे में हो, चाहे और किसी मामले में हो, वो इसका बेनिफिट उठाते हैं और सीधे जो है पेटेंट, कॉपीराइट या और जो भी आईपीआर के पार्ट्स हैं उसमें वो रजिस्टर्ड करा लेते हैं। तो आज जो है ये जो टॉपिक डॉक्टर वरुण चाचा ने चुना है, बड़ा बर्निंग इश्यू है। सर आप जो बोलेंगे वो अथॉरिटी होगा, बच्चे हमारे उससे हम लाभान्वित होंगे। इसी तरीके से हम आशा करते हैं कि भविष्य में भी हम हमारी फैकल्टी पर आपका स्नेह बना रहे। थैंक यू वेरी मच।
Thank you so much, sir, for your enlightening words. Now, I would like to introduce our distinguished chief guest, Sri G.R. Raghavendra ji. G.R. Raghavendra ji is a civil servant from Central Secretariat Services, 1998 cadre. At present, he is Joint Secretary, Department of Justice, Ministry of Law and Justice, Government of India. He is also a mission director for the National Mission for Justice Delivery and Legal Reforms. He is driving policy reforms for improving enforcing contracts parameters under the Ease of Doing Business and e-courts project. Earlier, he was Joint Secretary in Department of Industry Policy and Promotion, Ministry of Commerce and Industry, Government of India. There, he had also had the additional charge of Director General, National Productivity Council. He is former Registrar of Copyrights of the Indian Copyright Office. He played a vital role in introduction of the recent amendment to the Copyright Act 2012 and Copyright Rules 2013. He attended many WIPO and FTA negotiations as a member of the Indian delegation. He made significant contribution to the recently concluded two WIPO treaties, namely Beijing Treaty on Audio-Visual Performance 2012 and Marrakesh Treaty to facilitate access to published work for persons who are blind, visually impaired, or otherwise print disabled. He has contributed in revision of the copyright legislation of Bhutan, Cambodia, Myanmar, and Nepal as a copyright expert. As a resource person, he is a regular visitor to n number of international and national organizations and universities and institutions all across the world. G.R. Raghavendra ji holds several degrees and postgraduate degrees, namely MA Developmental Studies in Public Policy and Management from the Institute of Social Studies, Hague, Netherlands. He has done his MA and MPhil in Ancient History and Archaeology from the Osmania University, Hyderabad. He holds LLB degree from Delhi University and LLM in IPR from Guru Gobind Singh Indraprasth University, Delhi. He is also pursuing his PhD in IPR from the Guru Gobind Singh Indraprasth University, New Delhi. We are really delighted and honored to have you here, sir. I think there is some technical glitch.
वो बीन से छोड़ दिए ना।
So, as I already told you that the brief introduction which I have given you is not something, which is required for G.R. Raghavendra ji, but G.R. Raghavendra ji has done tremendous work in intellectual property laws across the world. As I told you in his introduction, he is the best man for IPR in India with us. And we are very, very fortunate today that he has agreed to deliver a very important keynote issue on intellectual property laws and its interface to access to education and access to health. Without any further delay, I would like to request, it is an honor and a privilege, that please throw light on this important topic. Please, sir. You're most welcome, please.
Thank you, Varun. I would like to thank organizers of University of Lucknow, the law department, and Dean Professor Singh, and you, Mr. Varun. Thanks a lot for inviting me to talk to your legal ecosystem people on this very important topic, intellectual property rights and access to medicine and access to knowledge. You're all aware that we are going through this unprecedented pandemic, COVID pandemic. And during this pandemic, we have heard a lot of talk about access to medicines and intellectual property licensing, whether IPR going to stop the developing countries and least developed countries access to vaccines, not only the vaccines, other COVID medicine and COVID related medical equipment and various other medical devices, which are all protected by intellectual property rights. Few may be protected by patent, few may be combination of patents, trademark, design, including copyright law. So when a country is not producing these kind of vaccines, medicines, medical equipments, and other systems which are most useful for saving the lives of people who have been affected with this COVID infection, and also protecting them not to be infected, so vaccinating them. So it's a huge challenge to most populated countries like India. You all know that recently India has been hailed all over the world as the the medicine, the entire medicines which we are supplying, the generic medicines or vaccines or various other equipments. India is hailed as pharmacy of the world. So why India is called pharmacy of the world, not any other developing country like United States or European countries like Germany, France, Italy, UK, and not even most developed Asian countries like Singapore, Korea, Japan, including China. So why India is a pharmacy of world? So it is because the intellectual property right policies which have been followed by government of India right from our freedom 1947 till during the last 7 years of our beloved Prime Minister Sri Narendra Modi's prime ministership. He started a health scheme program like Ayushman Bharat. The latest data says that more than 20 crore people who are below poverty line, who are eligible for the health scheme, got the access to treatment and medical treatment for various diseases, including COVID. 20 crore people, and it will go on. And then again, the Prime Minister Modi started another scheme, which is very, very important. That is Jan Aushadhalaya. Jan Aushadhalaya, the scheme, it's a medical shop. More than 5,000 medical shops are there in each and every nook and corner of the country. And one can boldly say that at least there is one medical shop in a district. There are more medical shops in a district. I can vouch for that. So what does this scheme do? They provide most cheapest biosimilar, equivalent generic medicine, which is life-saving drugs for most of the diseases. I give you an example. My mother recently passed away in January, and she was undergoing a treatment before that. Bi-monthly medical bill. That means only the medicine bill was 5,000 if I go and buy this in any ordinary medical shop. So one day, my cousin told me, "So you keep giving lectures on all these topics, access to medicine, blah blah. Why don't you try your own the central government shop, Jan Aushadhalaya?" So I was feeling that I'm such a senior person. So that is for poor people. Why should I go and disturb? But I came to know that anyone go and buy. There are plenty of medicine available there. Then I went to find out, to my shock, the 5,000 rupees for the 2 months I spent got 450 rupees. I gave it to my mom, and it was equally efficient, equally, therapeutically efficient. Typical doctor or pharmaceutical parlance, if I explain you to that. So this kind of scheme for the poorest of the poor can access to those medicines. The government of India, under the leadership of Prime Minister Modi, started the Ayushman Yojana. So these schemes are there. Then comes how India got the name pharmacy of the world. The moment COVID pandemic started, no country in the world was prepared for this. We did not have N95 masks. We did not have oxygen, ventilators and all that. So, and other equipment, we had to rely in the initial stages importing this. Then we became Atmanirbhar as per the Atmanirbhar Bharat's policy of the government of India, which, and again, Prime Minister Modi gave a call to follow this scheme in March this year. The self-reliance has been achieved in production of N95 masks or ventilators, etc. You walk in the street, anywhere you can find N95. Before that, it wasn't so. Uh, and not only that, when vaccine research started by most of the multinational companies of the United States and Europe, and we did not wait for that. We knew it's going to take a lot of time. For example, the first vaccine announced by Pfizer, Pfizer's vaccine, and they were granting the license, the patent license for reproduction. Without getting a license, it's a patented medicine. Even though the patent is pending, you will be challenged for illegally manufacturing those vaccines or medicines in India. So Pfizer was giving these with the dangerous clauses, which challenges our sovereignty and challenges the respect of India, which came through in most of the television channels, especially Vion broadcast a detailed program on that, how it is deleterious for our independence. It's selling our sovereignty and independence to one multinational drug company. Don't that this is too much. So we started our own research simultaneously. So the government of India, the ICMR, and various parties involved in the venture started by Bharat Biotech, a generic pharmaceutical industry company in Hyderabad. They came out with Covaxin. So Covaxin is a successful vaccine in India. We not only we use in India, we because of the contractual obligations, because various the raw material, the active pharmaceutical ingredients, etc., to be imported for preparing that. So those contractual obligations made us initially to export. Similarly, another successful venture happened in India with the signing of agreement with AstraZeneca and Oxford vaccine called Covishield, which a private pharmaceutical company, Serum Institute of India in Pune, got the contract, and they started producing the Covishield with a new name. So two vaccines started. When licensing was given to Serum Institute of India to manufacture Covishield, it came out with lot of riders that it will be sold in India, it will be made available to India at this price, and you can't export it. If you export it to these countries only, X group of countries you will export. don't export it to Y group of countries, and this is the price for the export, like this, because, and we wanted to save the lives of India. It was agreed to, and it started. And again, the contractual obligations made to the Serum Institute to export to other countries. People foolishly starting, Modi ji, mere bacche ke liye vaccine kaha hai, why are you exporting? People not knowing these things are making funny comments with a top vacant comments. So we don't go into such politics. Here we're talking about intellectual property and access to medicines. So government made its utmost efforts to make these vaccines available. Now today record is more than 55 crores Indians at least got one vaccine. The double dose will maybe efforts are being made. The third, there are other vaccines on the various stages of clinical trials or getting marketing approvals. So how these are all happening? So there are various kind of vaccines being generated. So one is nuclear acid vaccines. These are the one variety of nuclear acid vaccine is mRNA based vaccine, messenger RNA. And example is Pfizer and Moderna vaccines. These are all mRNA vaccine. So far in the world, no one has created messenger DNA. The other, if science students know, the nucleus has two chromosomes based systems, cells. One is RNA and DNA. So the problem with the Pfizer mRNA and Moderna mRNA, you need a strong cold storage system. Not only are the manufacturing facilities, as also the supply systems. Everywhere you should have, it has to be traveled in a cold storage, it has to be stored in a cold storage in a hospital. Everywhere cold storage system has to be managed. Whereas I'm just coming to that. So DNA, the messenger DNA has not been produced, not even by the most famous multinational pharmaceutical company in the world. But that Shreyash, that credit goes to India. One of the pharmaceutical companies called Zydus Cadila. It is the fourth largest generic pharmaceutical company in Gujarat. It has invented R&D messenger DNA. What is the beauty of this DNA? All the vaccines, whether Johnson & Johnson is a different one. You need only one dose, whereas other vaccine you need two doses, two jobs. Now the experts are also talking about the third job, the booster dose, and some other experts are talking about the annual doses. Even though you take third one, the booster dose, that may not be sufficient because the COVID strains, they keep mutating. The moment you get a job, your antibodies are strong to resist that. The COVID virus is also very intelligent. It starts mutating. It mixes up with the various varieties. It's mutating with a new name and then try to attack. That is the reason why many of the people who got double dose are still got infected. Luckily, they did not get hospitalized. The number of deaths are very ignorable. But coming to the messenger DNA, which Zydus Cadila has come out with a new one, beauty of this is you don't need to take a job. It's an oral drop medicine, just like you get any other oral drops for polio. You remember polio drops are given to kids in the orally. 2-3 drops are given orally, finished. So, and you and me take, of course, I've taken vaccine double dose 4 months back. I'm safe. But in future, anyone to be given a vaccination used by the Zydus Cadila's medicine, vaccine, that is messenger DNA, and that's only oral medicine. 3 doses orally administered, that's finished. Only thing is, instead of 2 jobs of other medicine, that has to be thrice, with some timings and all that. So how these are all inventions happening? How these are all protected? You all know all these medicines and devices are protected by patent under the patent law. That's why the TRIPS Article 21 TRIPS says that what is the patentable subject matter? That any patent can be granted either for a product or a process in any field of technology, provided it passes the 3 tests. One is novelty, second is inventive step, and third is the industrial application. So pharmaceutical industry, with all the medicines and equipment are patented. Of course, a few equipments and devices get design protection also, and their names get trademark protection, and any material published by them for advertisement, they get copyright protection. And some processes which are not patentable, for example, data, the clinical data, if that is not protected under the copyright, if there is no originality, that can be protected under trade secret law by signing the non-disclosure agreements. Similarly, the supply and marketing strategies of these medicine companies can also be protected in the trade secret. So that is the reason why when the vaccine production started and vaccine got approved by the respective countries, drugs authority, both approval for the emergency use or general use or marketing approval, the countries like USA, they booked more than 85%. Even EU countries have done the same. UK has done the same. 85% of production of these vaccine made it to their own nations. So a kind of vaccine nationalism started. And then other countries, countries like India could manufacture a couple of things, and remaining are in the pipeline. We got a license for Covishield, and we are doing that. But how about the other countries which are poorer, no capacity to production, and can't get the license, don't have the sufficient wherewithal to do that? That's the reason why WHO came with a program called Covaxin. So under this, they will give the money there, and they will obtain the licenses and they provide the medicine and vaccines to these countries. But unfortunately, this vaccine nationalism has stamped the availability of Covaxin. So, and the world population is more than 650 billion. In India, we have 130 billion. We need 130 jobs, 130 vials for making those vaccines. Well, vaccine have to come in a small bottle called vial, and then we need 130 injections because of since AIDS came, injections are not reusable, use and throw. So many things are associated. So considering these things, how to get the licensing? All intellectual property experts talked about TRIPS Article 31. There is a compulsory license clause is there, and India, after harmonizing this with the TRIPS, has introduced compulsory license provision. So how we are giving these patent grants, and also giving compulsory license to produce a cheaper medicine, accessible medicine. So once we got independence, there was an overall review of our intellectual property law, basically our patent law, which was introduced by British prior independence. So they introduced to protect their multinational companies which manufacture various medicines, antibiotics, and all that. So they introduced in India. Because we followed our traditional systems, Ayurveda, Unani, Yoga, Siddha, and all these systems. So it was English which introduced that system in India. So we wanted to produce that, and patent licensing is so expensive. Our companies which are coming forward to produce these medicines in India, make that available cheaperly to affordably to Indians could not be possible. So why? Because it granted both product medicine and process medicine. And so it's not easy to innovate and have a generic medicine in those conditions. So what India did, appointed two committees, one by Justice Tekchand committee. He gave a report, followed by the Justice Iyengar committee. So both committee recommendations said that Indian policy of the public health policy should help to make available affordable medicines and accessible medicines. Each and every poorest of the poor should be able to walk to a medical shop and buy a medicine without any problem. So if medicines are expensive and doling out, that will be a big problem. Then what happened in 1970? New patent law was introduced. We removed granting patent to product patent. So we had only process patent. For instance, I give you, take paracetamol. So paracetamol is held by patent rights held by a multinational company. How generic companies are making just 10 rupees, 15 rupees, you get a stick so cheap because they don't copy that process. They do re-engineering research. They come out with biosimilar, bioequivalent medicine, and without copying their process and without unauthorizingly appropriating their not only the research and development data and even the clinical test data. So when there is a biosimilar medicine, bioequivalent medicine, there is no need for clinical test again. So it is proven that it is more the same therapeutic effect it is giving. So they get clearly the approval and then go. So this is the reason why India has become a pharmacy of world, hub of generic medicines over the years. For the last 40, 50 years, that has become a comparative advantage. We export these medicines. Famous companies like not only Jadis Cardella, Bharat Biotech, Doctors Reddy's, so many are there. So many, Ranbaxy. So these companies have come up and producing all important medicine and making this accessible to the poor and needy because of these policies. So when TRIPS came, everybody was scared because Article 21 introduced not only the process that it became obligatory for India to introduce product patent. So we did it with a lot of careful exercise. So what we did, we introduced Section 3D, that and it says what is not an invention. So any medicine, for example, paracetamol is there. Paracetamol is patent protection 20 years ended. So and with the moment it is ending, the company comes out with paracetamol plus, for instance. It says that previously that the alpha particles were there, now the minerals are beta particles. Now in ozone ring कुछ ना कुछ एक chemical उसमें add कर दिया, and this therapeutic effect is more. So earlier paracetamol, when you used to take, it would have taken 4 hours to relieve the pain. It takes only 2 hours, 1 hour. So you give me a patent again. The bloody तो उल्लू बना के patent बढ़ा रहा है. So we said that under Section 3D, so new form of old medicine, medicine is not an invention. It's not an inventive step. There is no novelty, so you don't get a patent for that. So this was challenged in a court. So what is that challenge given to us? That is very, very important, that evergreening of patent is not allowed. One medicine called Gleevec, it is a medicine for intestinal cancer produced by multinational company Novaxin. It's a German company, Novax. What happened? It was rejected. the assistant controller rejected. They went to appeal to Madras High Court, then Supreme Court. Everywhere it was proved that Section 3D is effective. It comes under the TRIPS compliant. So it is very, very important for access to medicines and to stop unnecessary evergreening of patent. And the Parliamentary Standing Committee, which approved this provision, gave a lot of thought to it, and all left, right, and centrist parties supported this, because when nation comes first, nation comes first. So everyone said Bharat Mata ki Jai, Jai Hind, and then supported this. So that's the spirit of India in providing the access to medicines. Then comes the great compulsory licensing. People talk about, why can't you go for compulsory licensing of these COVID vaccines? Simple. You start producing Pfizer or Moderna, or there are other varieties like for example, the Covishield itself, virus vector based. So virus vector. So they take about that protein and then start doing the vaccine. Whereas our Covaxin is dead virus, means the dead virus is injected inside us, and that attacks when the actual live virus comes, it creates antibodies to kill the live virus. And there is another vaccine variety is called, a protein virus vaccine. Novavax, it's a company, multinational company in the US, which makes that fourth variety protein based, which improves our antibody production system in the body the moment you take that vaccine to fight COVID virus. That medicine name is called Covovax, is made by company Novavax. So like this are there. So people talk about compulsory licensing as per the Indian Patent Act provisions. So that's true. Any layman that, just like you are given a compulsory license earlier for a medicine called it is Nexavar medicine of Bayer company. It's a Bayer company. And again, Nexavar medicine, again, colon cancer medicine, if that is to be administered as per the doctor's prescription for 1 month, means patient has to take twice a day this tablet, means he needs 60 tablets a month. What is the cost of this medicine? 2,80,000. Imagine a poorest of the poor guy gets this. How can he, afford this? Even a normal guy, and even upper middle class guy can't afford 1 month medicine with 2,80,000. So it is as per the rules of the patent, the compulsory licensing. I'm not going to the legality. In general, I'm talking about. So it is, a patent has failed, even though you granted patent. So it is locally, it is not function, because it is not available, and it is not being manufactured. Even though it is manufactured, it is not affordably available to the people. So compulsory license can be granted. It was granted, it was challenged again. Supreme Court case came in the favor of this compulsory license. So people were talking about simply why government is not granting compulsory license under emergency. There are conditions which even Article 31 of the TRIPS talks about. When the Doha Declaration happened, the ministerial conference in 2002, because these are all flexibilities provided in the TRIPS agreement for the developing countries and developing countries, because general principles of Article 7 of the TRIPS agreement and the objectives of 8 of the TRIPS agreement talk about the balancing of intellectual property right between the right holder and public interest. And Article 8 talks about public health and transfer of technology and all that by licensing, and also abuse of rights. IPR should not happen. Competition should be allowed, and abuse of monopoly should not happen. Even Article 40, which extensively talk about promotion of competition and all that through technology transfer and allowing the generic medicine and all that. But the pharmaceutical companies, multinational pharmaceutical companies always worried about their patent. They go and complain to US government and put in India in priority watch list of Super 301 report every year. But we don't give a damn. We simply trust that because we have because no foreign laws can be run in India, and we have our own sovereign. Our laws are totally in compliance with the international treaties and agreements, whether TRIPS of WTO or other intellectual property treaties and agreement which India is a member. So here, what happens that these compulsory license interpretation was restricting. In Doha, it is said that the famous paragraph 6 of the Doha Agreement talks about amending the TRIPS agreement, introducing a new article with the number 31 bis. What is the beauty of 31 bis? It says that compulsory licenses can be issued for the access of medicines in the third world countries, and TRIPS flexibilities will allow that. But it comes with, again, riders that you can't export. Export can be happen only these conditions, blah 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 blah. The way condition has been put on the Serum Institute for exporting the Covishield to other countries. You can you can sell it to them, we can't sell it to them with these price, to them with this price, to them, and all that. These things are unwieldy totally. When there is a pandemic and when it is attacking people irrespective of their social position, irrespective of their bank balance, irrespective of their skin color, caste, and sex. We can't have these kind of binding legal provisions at international level and national level because access to health is important. Vaidyo Narayano Hari. That's what our Hindu scriptures talk about. When you person who gives medicine, he is a god. Narayano Hari. So all doctors, that's why we treated during the pandemic. Why we bajao tali for them? It's not a drama as people that, because we respected them as the god, because risking their health, they served us. In Delhi itself, more than 200 doctors died because of COVID. I don't know, it must be in the huge numbers in India. They did not feel threat to their life and their work. So, but as a person, an intellectual property expert, I feel that medicine has to be available. So these restrictions are there. How to make this medicine available? That is the reason why government of India, in collaboration with government of South Africa, submitted a proposal for the TRIPS waiver, amendment to the TRIPS agreement in the TRIPS Council and the World Trade Organization. So it initially, with a lot of hesitation, US opposed because the pressure of their multinational drug lobbies, companies, they understood the human rights aspect, the way COVID was spreading. The moment Joe Biden took over as US president, he came out and supported. India gave hydroxychloroquine and paracetamol in more than 140 countries. More than 90 countries got the Covaxin and Covishield vaccines. And then we also exported, before the second wave started, a lot of medicines and also the medical equipment to other countries. And then, unknowingly, the second wave started, despite government was warning. And then we, general people, public, did not take that seriously, and without following the social distancing and without wearing masks and without following other COVID appropriate behavior, and we ourselves are responsible for spreading the COVID. And then imagine with a 100-bed hospital, 1,000 people go seek for the ICU bed in a day, how that can be made arranged. And 200 people oxygen facility available, suddenly 2,000 people come for oxygen facility, how it can be made available. But government sent the oxygen trains all over India. more than 20,000 metric tons of oxygen has been made available. PM Cares Fund was released, funds were released, and each district one oxygen generation facility has been, the money has been released to set up that. It is for the state governments to do that. So these are the important provisions for the access to medicines. And one more thing is patent linking. So this concept is a TRIPS plus element, which most of the developed countries say, like US and Europe. What they do when a patented medicine gets, Federal Drug Authority approval, and they go for the market approval. The marketing drug approval agency sees whether a patent has been granted or not. If a generic medicine comes, they say that, look, other medicine, the main medicine got the patent. So that is the reason why they got the marketing approval. Since patent is linked with the marketing approval, you will not get marketing. So this nowhere written in the TRIPS provisions. So India says it's all bullshit. It is all multinational pharmaceutical companies' drama to sell their medicines and stop others to produce that biosimilar, bioequivalent generic medicines. We don't give a damn to that. So they went to court. They went to court and filed a case in Delhi High Court. So Delhi High Court said clearly that this is illegal. The Bayer versus Union of India. In this, they said that Cipla manufacturing this medicine. Cipla is a generic drug company, Indian company. They're manufacturing a drug of Bayer. They try to, their lawyers try to explain the linking the Drugs and Pharmaceutical Act and patent provisions together. And Delhi High Court trusts that argument that even though harmonious reading happens of two different laws, they may be Indian laws, Drugs and Pharmaceutical Act and patent law provisions. There is no concept of patent linking in the TRIPS itself. How can the government of India introduce in both acts? So it is against the public health and access to medicine. We don't agree to this concept. It's a TRIPS plus court itself said. So this is the thing. And another important badmashi, again, the TRIPS plus thing is data exclusivity, the concept, stopping the access to medicines. The concept of the multinational companies and developed countries. What is this data exclusivity? You take, for example, Pfizer medicine, vaccine for the COVID. When they manufacture it, they have a lot of research, R&D, phase 1 research, test, and maybe on the animals, and phase 2 on the human beings, again, phase 3 on the human beings. All this data is collected, how this medicine is working therapeutically, how much percentage is effective, and shielding the human being from the COVID virus attack. So this data is kept closely to them. When they submitted to the authorities for approval, they say, look, we have spent so much billions of dollars and so much time. No one should get this for so many years. So they fix the time of US 5 years, and EU 8 years, Japan 10 years, or some other country 10 years. It means the term of patent is getting extended. From patent term is the exclusive the term is given for them is 20 years. So additional 5 years or 8 years or 10 years are getting, it's totally illegal. They say it's not illegal. Article 39, which talks about undisclosed information in the TRIPS agreement, paragraph 3 talks about protection of undisclosed data. I mean, this is what. But where is it you protect for additional so many years? So it is a wrong interpretation. The famous intellectual property experts who have written a note for the UNTAD, so United Nations Conference for Trade and Development. The significance of this body has come down after the World Trade Organization has been set up. So the interpretation of these provisions, what they talk about, there is the 3 models existing in India, in the world. That is TRIPS plus model. That is data exclusivity, giving 5 or 8 or 10 years to this data. And the best method is what India does, this misappropriation method. Somebody unauthorizedly, unscrupulously steals this data, that has to be protected. That's all. But some countries, other than India, few countries introduce compensation. The recognizing the money and time spent by the invention of R&D and testing clinical tests and all with these companies. Some countries introduce the compensation theory by हम इतना पैसा देंगे आपको agreement में, but that money is decided by the government. You can't demand so much. So this compensation amount is given to you so that you allow production of generic medicine. हम बोलते हैं ऐसा कुछ नहीं है. We neither follow compensation theory nor data exclusivity theory. तो एक ही theory, चोरी मत करो. चोरी मत करो. भगवद गीता में बोलते हैं ना, चोरी करे तो नरक में जाएगा. So you use your intelligence, you innovate the new process, you develop biostable medicine and get approval, market approval, sell in the market. That's okay. So these are the access to medicine policies. Another beauty of the policy, most of the people must have come to know, many people don't know this, but this policy has become very famous during the COVID pandemic, the second wave, that is fixing of prices of various medical equipment, various medicines like remdesivir by government of India. There is a National Pharmaceutical Pricing Authority under the Department of Pharmaceuticals. They fix the pricing for the essential life-saving drugs and equipment. So this national essential price list they bring out, and that is the recently they introduced the remdesivir also. You must have seen people were running around about, everybody has become a doctor. They were buying medicine, administering remdesivir at home, so silly. And it's not a life-saving drug. That's what the ICMR said, finally declare, and even WHO declared. So people thought that hydroxychloroquine going to be best medicine for treating. It's a malaria medicine. It was used as a trial and error type, and then everyone after hydroxychloroquine. That's why India, donated to many countries and then sold with many countries, more than 140 countries. Then came and the blood plasma therapy, and then everyone was rushing the plasma. That the crazy of the blood plasma. Again, the ICMR came out with announcement that it's not a cure. Many people died even after taking the plasma therapy, and people becoming heroes, many freely donating. So it's a big salute to them who donated the plasma, but it was of no use. Then came remdesivir and all that. Most dangerous thing later came, because one of the UK trial came that another medicine which is very effective, and that led to a lot of black fungus and other things, misuse of that medicine. So like this, the right medicine, making the right medicine accessible is very, very important. And then the moment this proposal was floated there, then questions were arise whether how many countries have the capacity to manufacture these vaccines. So India is a pharmacy of the world. We have more than 40 pharmaceutical companies already. The manufacturing, you need not only the infrastructure, you need scientists, you need technicians, you need experts, you need cold storage facilities. All these things should be there for simply giving a license to manufacture is not enough. The Covaxin license was given to Hopton Institute, Mumbai, 3 months back. Still, they are not come out with the first, first lot. It takes time. It's not that easy. So even TRIPS, only way is people are talking about voluntary licensing. When HIV virus was spreading all over the world in 80s, like the same problem was there for the developing and least developed countries, lack of access to this HIV virus medicine. So many US, United Nations led medicines patent pool started, and WIPO also started WIPO research, and various things started. But I know these voluntary licensing, it may be giving non-exclusive, non-transferable license to produce these medicines for the cheaper way, affordable way, but it came with a lot of conditions again. So many high-level developing countries like China and Brazil and other countries could not get the licensing, even the voluntary licensing to manufacture these HIV medicine. during that time. Luckily, India got the Gilead medicines and other medicine for the Cipla and other companies. Medicine patent pool may also not be that successful. So a combination has to be there. Even though the TRIPS waiver comes, we should be technically ready to produce more and more vaccine, because vaccine shortage is a much talked about, but government is making its effort to supply the vaccine to equally to all the states, and hopefully we'll be vaccinating all 138 crore people soon. Then I'll jump to access to education. So again, during the COVID times, now we are, instead of traveling to Lucknow and physically giving this talk, this online networks are facilitating me to talk to you from my residence on this holiday Saturday, to all the intellectuals of the interested in the intellectual property right law. And thanks to my friend Dr. Varun, and also, of course, my teacher who taught me in the law college. Okay, so now we're all interacting because the copyright exceptions are there for education. So India has been a champion, just like India has been a champion in access to medicines, access to knowledge. Also, India played a great role at national and international levels. So when Berne Convention said that reproduction right, there are exceptions for the quotation, education, and for other purposes, research purposes, scientific research purposes. They said, we said that that is not sufficient. We want exceptions not only for the reproduction and translation as well, for all purposes of education and research. So there was a revision conference way back in 1967. It was held in Stockholm, famously known as Stockholm Berlin Revision Conference 1967, where India fought for the exceptions. So because of India's fight, so in Article 9, a new paragraph 2 was introduced, that is today is famously known as three-step test for reproduction right. What is that? So any exception for copyright can be introduced, because copyright is also exclusive right given for the life of the author plus 50 years as per the Berne Convention, and India introduced for life of the author plus 60 years. So the exception can be given once the policy passes the test, three-step test. One, certain special cases exception can be given, copyright exception, just like education, research. And number two, that does not conflict with the commercial exploitation. When author publishers selling books in the market, so giving these educational exceptions, student go to the library, photocopy, borrow the books, and Dr. Varun also gets that copy, and he photocopies and research and give copies to the students. The famous Delhi photocopy case of Rajeshwari photocopy at Delhi School of Economics, a case filed by most of the foreign publishers in Delhi High Court. Justice Rajiv N. Law, who retired recently, he gave this judgment later. A division bench led by Justice Pradeep Nandrajo confirmed that judgment that said that all the amendments introduced to the copyright for the educational exceptions in 2012 amendment, they read out the legislative intent. So while drafting the act, what we were thinking, so he simply read out. That's the beauty of that judgment. He said that when education, these are all needed. When, for example, Dr. Varun is going to take a class, before the class he starts preparing for that, he may collect the material, or he may ask a few researchers to collect the material and give it to him. Then he once prepares and go to the classroom, he's communicating in the class, public performer, he become a performer at the time. So all these are copyright exceptions. Students reproducing it and as a notes is copyright exception, or he is giving photocopies is a copyright exception, or showing a PowerPoint presentation is a copyright exception. And then doing a research is a copyright exception, non-commercial, educational research. And if he comes across on the topic few German, a few French language books, he asks the librarian to translate those pages relevant to his topic. The translation is done again, that is educational exception. So author and public publisher need not object to that. So this is the beauty we wanted to introduce at international level, and we did it at national. We reach section 52 of the Copyright Act. It's crystal clear. That's what the Justice Rajiv Hendla or Nanda Jog talked about in Delhi photocopy case. So, and not only we stop there, the third test is which does not conflict with the, which is does not prejudicial to the interest of the author. What is this third test talks about? Does not prejudicial to the interest of the author. It says when a student goes to book library and borrows a book. Fortunately, India, we are not introduced a lending right to the author and publisher. Otherwise, royalties should have been paid, just like Western countries, EU countries, they have such right. We are a developing country, considered the poor country at the time when we got independence. We simply ignore this lending right. We never introduced that. He goes to a photocopy shop and photocopy. So it is a private copy and personal copy exception is there. What is the difference between personal copy exception and private copy exception? Personal copy exception is Dr. Varun again writing a research article. He wants to collect some material. He'll go and photocopy it. It's a personal copy. What is the private copy? He copies couple of pieces, let us say 20 copies, and circulates in the classroom. That is a private copy. So he's copying not for him, for his students. So these are the two examples, difference between personal copying and private copying. So these things we introduce. So they say that world over, the developed countries, when you do that, author's commercial right is, publisher commercial right is exploited. So prejudicial to this photocopying. So some compensation has to be given. Say they introduce private copying royalties. So India, influenced by many people, in 1991 introduced copyright cess bill in the parliament. Luckily, after that, TRIPS came. TRIPS came, and then TRIPS negotiations were happening at the time. To commercialize education, they introduced it. Later, some good sense prevails. They made that bill die in the parliament. So never reintroduce or make that. Otherwise, the photocopying would have been more expensive in India, not like the way you get 50 paisa copy or 1 rupee copy. It could have been more. And then all these things are made us to improve access to education. This is very, very important. So 2012 agreement, we introduced access to books, access to education, book in hands for the blind also. So blind people, except braille copies, they could not get books on each and every subject, each and every fiction and non-fiction. Just like we walk into a library, get a book, we walk into a bookshop, we get a book. Book of our choice, book of our interest, book of the subject also. But unfortunately, blind students, physically disabled students, which have to maneuver the latest electronic equipment to read, they don't get that facility. So finally, technology facilitated reading books for them. Special formats have been made, provided. But such conversion is infringement of copyright unless and until such permission is granted by the right owner, whether author or publisher. So we introduce exception to such licensing to be given to the blind people and physically disabled. And section 52 1ZB in the Copyright Act amendment in 2012, we said that any organization or any person, including next of kin, means a blind person is there, he can't make that special copy. His parents may be making, his siblings may be making, or his friends may be making for him. So that is also not infringement if they are doing. Even any NGO is doing, it's not infringement. If a Delhi University or Lucknow University is doing, it's not infringement. They're all authorized entities, non-profit making organization making this, available to blind students. And no, we did not stop there. So publisher said, okay, we'll make the available that in the market, just like the sighted people go and buy this in the market, let the blind people come and buy it. But we said, okay, but we know that these books are simultaneously not made available. Same day, if Dr. Varun Chacha writes a latest book on Constitution, he knows that the blind version is not available in the market, and the same day, बेचारा blind student कहाँ से पढ़ेगा? Huh? So, and then Varun Chachar has to convert it in his law school, Lucknow University, and make this available to blind students. Then the publisher will kill him. He said, you may be author. You have transferred copyright to me. Publisher says that copyright is not allowed. So what will he do? So you know that any article written by Dr. Varun Chacha, he can't share it on social media because he has given all the rights to the journal. Varun Chacha has to log in and read and then just go, come on. So maybe he's allowed to take a print or not. I don't know. Yeah, forget about he can't share. He can tell that Raghavendra ji, if you are subscribed to that magazine, please read. Or I go to my library and use my library's login ID and password and open and read. So this is the copyright shackles. So we have broken these shackles, even though the encryption devices put on this, not allowing to break that. We said breaking such encryption devices is legal for these purposes, providing for the education and research, especially providing to the blind. This is what we took to, at the international level when Marrakesh Treaty was happening. US and EU was against. We became one of the leaders in promoting in the name of human rights. So we read out provisions from the United Nations Declaration of Human Rights, United Protection of Physically Disabled, all those articles we read out and put that in the preamble of this Marrakesh Treaty. And commercial availability, even though in the book is available for the blind in market, which may be very not affordable, very expensive, or it's not available when the student needs it. So Dr. Varun Chacha or Lucknow University, which being a authorized entity, can convert it and give it to them, even though it is commercially available. This is what which EU and US was opposing. We achieved grand success at the midnight of 11:55 in June on June 28th. I remember that day in 2013. So I'll share that video when we were celebrating with the blind people in the conference hall. Still, it's a dear to me, that God-given role to me to help blinds to access books. So these are all the access to information, very, very important. And but please do not indulge in plagiarism. Do give respect to the authors whenever you write a research paper, thesis thing. Do give a citation, do give a reference. Quotation, when you are taking a quotation, even though converting into paraphrase, still you have to give citation and reference. So you simply you are good in English and you change the language, but the intent and the concept you have not changed. You must have changed only the language. So still you have to give reference. Even the few phrases you have taken, just like a dil mange more, or basic structure. These are the concepts. Basic structure was introduced in the famous case by Supreme Court, Keshavananda Bharti case. You can't misappropriate and start writing as if your own word without giving citation to that. So this is what. But there are unscrupulous people. Some people do single source plagiarism, copy from one book and complete their project work. There are intelligent people do multiple source plagiarism. They very studiously read 20 books and copy and cut paste and try to show you submit as their own book. And there are third grade, I mean, very intellectual people are there. They're very good in English. They simply paraphrase, read everything, paraphrase their own notes. They put it as if it's their own without citation and paraphrasing. These are the low grade is single source, middle one is multiple source, and the high grade is they won't show any source, their own language, but copying from everywhere. And another kind of plagiarism is self-plagiarism. Though intelligently he writes a book or an article, when writing the third one, he will cut paste his own thing, doing self-plagiarism without giving a reference, because he doesn't have copyright, and copyright with the producer, the publisher. That is also wrong. And another dangerous thing, the moment I registered for PhD, I don't know from where I got emails, even I keep getting now. So simply give your proposal for PhD chapters, and we'll understand and write each chapter and give it to you. So you submit PhD, you give us this much money. So this is ghost writing, ghost plagiarism, which I call it. So all these things to be avoided. Then finally, how plagiarism is checked by various so-called softwares, plagiarism check softwares. And there is a myth surrounded this. 15% is allowed. Somebody says 20% is allowed. Very intellectual senior professors talking about this. I simply ask this question: which provision of copyright law allows 20% infringement, 20% plagiarism? Please read me. So no plagiarism is allowed, not even 15 or 20%. Please remember. Then what is the fake books are being sold outside. There is a gray market. They publish books at a cheaper rate, and the book is Varun Chacha's book is 3,000 rupees in the top Jain book depot in Connaught Place. Footpath में लड़का मिलेगा सब you haggle him और 100 रुपए में दे देगा. How you don't get it? 10 रुपए का discount in a Jain book depot. This guy is giving 200 rupees discount. When I go to World Book fair, publisher, to attract a crowd, he will give maximum 15% discount. To sell the books. But the normal time to milta 15% of that is not equivalent to 200 rupees. You know that. 30 rupees maximum, 60 rupees, 90 rupees maybe. So usse zyada nahi milega. So how this is all fake, infringement of books happening. So this need to be stopped. What is the last my point I close before I close this? Difference between infringement and plagiarism. When Dr. Varun Chacha's book, pirated book, is sold in the market, student को भी पता है pirated book, Dr. Varun Chacha's को भी पता है, उनके publisher को भी पता है, a pirated copy है. Still people buy it and read it, to the economic loss of the author and also of the publisher. It is a legal construct, because legally it is wrong. There is a civil remedies, there are criminal remedies associated with this kind of piracy and infringement. Then what is plagiarism? It is it's an ethical construct, a moral construct. The guy who copies, he's fooling the buyer that I'm the author. Is it just like a trademark you are passing off? Here also he's passing off. Passing off others' work as his work as if he is written originally. So it may be a single source plagiarism or the multiple source plagiarism or ghost writing. Finally, his name is there, abracadabra. So this abracadabra is fooling the student, fooling Dr. Varun Chacha, fooling his publisher. So it is a moral construct. It's not only the plagiarism, infringement as well. This need to be discouraged. So with this, I thank Dr. Varun Chacha and Professor and Dean, Mr. Singh. If you have any question, you can ask me. Otherwise, Jai Hind.
Thank you so much, sir, for giving your precious time. And let me say that when G.R. Raghavendra sir was discussing this particular point of intellectual property law, and as I told you at the starting point of time that we have the best men, let me tell you this point that in last 1 hour and 14 minutes, we have understood the whole of the story. Now, this is what is a class. It's not an easy task because Raghavendra ji has covered each and every aspect with regard to access to education and with regard to access to health. And beautifully, that story of vaccine, which there are n number of misconceptions in the mind of the people at large, that what has happened, where vaccine had gone, this and that, and n number of stories. Now, every truth, has directly come to us. And now we understood that how, we as Indians, transgressed that particular limit, which was not easy for us. We became pharmacy of the world, as sir rightly pointed out with his a number of important instances. He told us how pharmaceutical industry developed in India with so many odds, and how the notion of Atmanirbhar Bharat, and he has given his personal instance of Jan Aushadhalaya. These are all those conceptions which are very, very important for all the students to know. It is important for all the citizens of this country to know that how the policies are made and how objectively we are directly benefited by those policies. And Raghavendra ji has made it easy for us, being a man with IPR expertise, and also a government man, by the way, making policies for us, making policies at the highest echelon of this country. I think, and the instances of plagiarism and that photocopy aspect and all those differentiation between a personal copy and a private copy. I mean, these distinctions are very, very difficult to get from sources. Today, we are very much benefited by you, sir. And I think again and again, we will call you so that our students and our faculty members and absolute each and every person who is interested in intellectual property law, copyright specifically, plagiarism is a huge issue. I'll again request you to come sometime and discuss this particular deliberation of plagiarism. There are n number of misconceptions in the mind of the faculties, n number of misconceptions in the mind of the research scholars, and there are a number of issues pertaining to the policy. So I will discuss, I will definitely request you to come again, and Lucknow University will definitely be benefited by this. Thank you so much, sir. We are really benefited. And let me tell you this fact that it is all because of our Honorable Vice Chancellor, Professor Alok Kumar Rai, sir. His guidance and his support made us bring all these qualitative discussions on panel. And I am really thankful to Honorable Vice Chancellor, Professor Alok Kumar Rai, sir, for giving us this opportunity to allow and even allow us to discuss all these deliberations on the university platform. And I would like to thank my head and dean, Professor C.P. Singh, sir, for encouraging us, for motivating us, and for guiding us in all respect of deliberations. Thank you so much, sir. And we will continue with all such academic endeavors in future. And we will request you definitely again and again for your presence in Lucknow University. Thank you so much. Jai Hind.
Thank you. Namaskar. Jai Hind.